Okay. Bismillahirrahmanirrahim. Nahmaduhu wa nusalli ala rasulihil kareem. Amma ba'd. Today we are going to talk about the next chapter in the uh, in the theory of contract, which is the classification of contract. As you can see in the slide, um, this is something. You already know. So what we are doing today is actually it's like I used to tell you this example of your closet, and you always keep your dresses in a way that you want to use it for your purpose. Maybe some of them you might want to use it on the occasion of something like official occasions, sometimes personal occasions, sometimes like a classes, sometimes even for going out, or maybe going to the garden, or maybe sleeping time. So you have this kind of this is what we call classification. So now when it comes to contract, so everything that we are going to talk about is around the 5 types of classification that we are going to talk about, is that you have already learned before. All right, you have already learned, but now it's like you are going to put those things into 5 types of classification. So now the first one is, I think, quite important, which is actually classification based on characteristic. Yeah. So let us talk about characteristic, then we move to based on purpose and effect. The second one, actually, you have already learned before. I also gave you this purpose and effect because you were doing some assessment last time. So I gave you this purpose and effect. Then we will talk about the time of execution. Then we will talk about based on the nominated and non-nominated contract. And lastly, we will talk about requirement of physical possession. So let us start with based on characteristics. I think here you are going to learn something new, which is fasid, irregular. Okay, what exactly usually when we say the characteristic of the contract, we will say whether it is the valid contract or invalid contract. Let's say if everything is fine, all the pillars are okay, we will call it valid. This is the character, yeah, the characteristic, whether it is right contract or the bad contract. So you will call it valid. In Arabic, valid means sahih. Yeah, sahih means valid. And then the invalid, or you can call it void. In Arabic, it's actually batil. So there is only 2 types of contract, whether it is a sahih contract or batil contract. But there is one more, which is actually the Hanafi. They are introducing the 3rd type of characteristic in contract, which is fasid. In English, we can call it irregular. So now let us see what is valid, what is invalid, and what is irregular. So the valid contract is a contract when all its pillars are correct. So the 3 pillars that we talked about earlier, if all 3 pillars are there in any contract, you can call it valid contract. But when one of them are missing, when one of them is missing, one of the pillars are missing, then, or maybe a condition, or maybe there is a wrong condition or something, then you can call it is a void or invalid contract. But what is this actually, number 3, irregular or fasid contract. So this is what actually you have the majority. Usually the majority scholars, they only classify the contract into two, which is valid or invalid. When it comes to Hanafi, they classified the contract into three: Sahih, Batil, and Fasid. So this is what we are discussing, this all under the first classification based on characteristics. We have 4 more to go. Okay. So now, according to Hanafi, this is where actually they are going to talk to you. What do they mean by valid, invalid, and irregular? Okay. According to Hanafi, the valid contract is the contract which is legal in its asl as well as wasf. So now what is asl and what is wasf? Asl refers to essential elements, which according to the Hanafi are offer and acceptance and all the conditions required concerning the parties and the subject matter. So now if you go back and remember how many pillars according to Hanafi, if you remember, I think you recently prepared for the test. I think it's not that difficult. Yes, Ramadan?
4, sir.
According to Hanafi, is it 4?
2, sir.
Hanan? Yes, Hanan. According to Hanafi, how many?
2.
2. Very good. Okay. Luckily, I didn't ask that question to you, Ramadan, yeah, during the test. Okay. So now, according to Hanafi, it is only 2, because they say it is offer and acceptance. Okay, the remaining all will follow. But there's only the first one is offer, the second one is acceptance, ijab and qabul. So now they say if anything missing within this asal, then it is. I mean, these fundamental pillars of the contract, which is actually offer and acceptance, and the condition concerning those offer and acceptance. For example, legal capacity, right? And then the subject matter and everything, will come under this offer and acceptance. How can you offer something if there is no subject matter? Yeah, that's why they actually mention subject matter is actually following the offer and acceptance. Also the parties. How do you make offer if there is no parties? So parties mean what? Buyer and seller. So if there is no buyer and seller, there is no offer and acceptance. And if there is no subject matter, which means the product, the one you are selling, whether it is a book or phone or car or property, whatever it is, if it is not there, this is not going to be, the offer and acceptance won't be there. That's why, according to Hanafi, offer and acceptance are the main 2 pillars of the contract. So whatever concerning the conditions, this is what we call asal. So now they said there is a asal and there is a wasaf. Wasaf refers to external attributes, right? The external attributes that are not in the essence of a contract, but falls outside of it. So now this wasaf is actually something, it's not something that what we are saying, offer or acceptance. It is not something that comes into the capacity, legal capacity, or So this offer and acceptance, other than the offer and acceptance, whatever comes outside the offer and acceptance, external attributes, it might be called wasaf. So now let us see why they have to mention asal and wasaf, because for the purpose of the irregular fasid contract. For the purpose of explaining irregular, they have to tell you what is asal, what is wasaf. A contract is irregular when its essential elements are present and all the essential conditions are complete, but it contains a prohibited attribute. You see, it looks fine. It looks like a valid contract, but because it is valid contract, because the pillars of the contract complete. You know, there is a offer and condition. It is offer and acceptance. There is a parties. Yeah. There is also a subject matter. This is what they say, conditions pertaining to offer and acceptance, which is legal capacity and also the subject matter. Everything is completed, but what happens that, for example, they don't know the price. They want to sell you the phone. So the offer is there, the acceptance is there, the legal capacities is there. So the major selling to the major, or major selling to the minor, but the minor with the guardian. All right. And then also the subject matter, the phone is there. The phone is there. The only problem is right now, they want to conclude this contract without fixing the price. So now, according to Hanafi, they will call this particular contract, they will call it fasid. They will call it fasid. When a contract contains elements of usuri, or when a contract suffers from a gharar, such as when a certain property is sold for an unknown price. Maybe there is an element of usuri, or something look like cheating or deception, or when a property is sold but without any price, then this particular contract is called fasid, irregular. The reason why others are calling this contract, this example that I told you, a property is sold for an unknown price. According to majority, this contract can be invalid. I mean, sorry, this, of course, it is not can be, it is. This contract is invalid according to majority. This contract is batil according to majority. But according to Hanafi, this is not batil, they call it fasid. Why they really want to make it fasid? Why they want to call it irregular or fasid? Because according to them, most of the majority, I mean most of the main part of the contract is correct. If you actually can change that particular part, which is, for example, the price is unknown, right? If you can make that price known in any circumstances, if you take out the element of usuri out of the contract, if you take out the element of gharar out of the contract, so which means that as long as the price is unknown, this particular contract is fasid. But the moment immediately you come to know the price, the moment immediately the seller reveal the price, then the same contract which we were calling fasid before, now the same contract becomes sahih. One of the example I can give you, the recent practical example, that when there was a car company, when there was a introduction to the new car, so they announced that this is the car. They announce, they show all the photos and videos about the car, but the car is still in the preparation. People didn't see the real car. They didn't see the physical car, or maybe they have seen one sample car. But most of the time they saw the photos and everything about the car. Everything means every spec and everything, the model, the size of the engine, the torque power, the seats, you know, and everything about the car they know. The only problem is the car company did not reveal the price. but they open the booking. They open the booking, which means that you can pay the deposit. It's like called booking charges. So what they say, whoever come and pay 500, we will start booking for you. So right now, the problem comes with the fiqh scholars. They said, if they already told you the price and you are paying 500 as a booking charge, because this booking charge usually will be deducted from the original price. Whether it is a refundable or not, that's a different scenario, different case. But the money that you are paying should be deducted from the original price. But right now we don't know what is the original price. How we supposed to deduct? How we supposed to know that how much is actually going to be deducted from the original price? So most of the scholars, even they said that this kind of contract is actually not valid. So right now, according to Hanafi, if you ask a Hanafi scholar, he will say this contract is actually fasid, irregular. It is not a complete, valid contract until the moment you reveal the price. So the moment they reveal the price, the contract becomes complete. So there is an opportunity, you know, to know this irregular fasid for some sort of circumstances. Some scenario might help this kind of contract. Similarly, a contract is considered irregular when it is made with a defective consent, such as contract made by a person under duress. A contract is also irregular if the parties agreed on void conditions. All these conditions render a particular contract irregular. Irregular contracts do not have legal effect. See, once it is being done, there is no legal effect. That's why, according to the Hanafi, until you remove those problems, the prohibited attributes, there is no legal effect, meaning you cannot become the owner of the phone. If you complete the transaction without knowing the price, still you cannot become the owner of the phone, and your seller cannot become the owner of your money until you know the price. So which means there is no legal effect. However, the contract could be corrected when the prohibited attributes are removed. Invalid or void contract, according to the Hanafi, is a contract where one of the pillar of their contract is defective. So this is clear, crystal clear. If you want to talk about invalid or void, which means the batil, according to Hanafi, definitely if offer and acceptance is not there, or if the conditions that completing the offer and acceptance, which means the subject matter is not there. For example, there is no phone at all. How you are supposed to sell? All right. If there is no capacity, the legal capacity, then of course this is what we call void and invalid, like everybody else. For example, the sale of a person who has no competence, or when a contract is concluded for an unlawful purpose, or the sale of invaluable property, or when the subject matter is not in existence. So in these circumstances, of course, like everybody else, Hanafi also says invalid. These contracts are prohibited contracts, and as such do not have any legal effect. Okay. Any questions? Okay. So let us go to the second one. The second classification based on the purpose and effect. So this one is actually what we learned before. Based on their objectives and effects, contracts are divided into 7 categories. I talked to you about this last time when I was giving you the assessment, the advertisement. Those are the very good advertisement assessment. You were doing very good. Uqud al-Tamlikat, acquiring ownership. You have sale, rent, gift, waqf. Then Uqud al-Isqatat, which means waiving rights. So this is another classification. Like I told you, you can actually categorize the contract based on the purpose and the effect. So you have acquiring ownership, purpose of acquiring ownership, purpose of waiving rights, purpose of authorization, like the guardianship or agency, right? Wakala, all this agency comes under authorization. Then you have imposing restraints, yeah. And then you have the providing security, uqud tawsiqat, kafala and hawala. Then you have partnership, like musharaka, mujaraba. Then you have the safekeeping property, right? Uqud al-hifz. These are the like safekeeping property. So these are the examples. I mean, these are the 7 categories comes under this, the second classification, right? This 7 comes under what? Classification based on the purpose and effect. Okay. The next one is the classification based on the time of execution, right? So now there are 3 under this. This is the classification based on time. So you have the immediate effect, you have postponed effect, and then you have effect on condition. Okay, let us see one by one. Yeah, contracts are divided based on the time when they would produce their legal effects after their conclusion into 3 types. The legal effect will happen according to the time. So there are some contracts will happen immediately. So this is what we call in Arabic al-aqd al-munjaz, al-munjaz, anjaza yunjizu munjaz, which means that it has to happen instantly. Yeah, these are the contracts which produce their legal consequences the moment they are concluded, immediately. For example, sale, pledge, gift. If I give you my phone as a gift, which means that it's happening right now. It is not that it will happen next year or next week. If I am selling something to you, if I'm selling my car to you, I said, okay, sold, which means that I'm doing it right now. And you are becoming the owner right now. It's not that it will happen next week or next year. So if they are postponed, the intended consequences are not attained immediately, and it is not allowed. You know, I cannot say that I give you my phone gift, but it will happen only the next week or next year, which means that the gift did never happen. If I say I'm going to sell my property, but you will become the owner only next year after I finish all my payment, then which means that it did not happen now. Maybe next year only it will happen, right? In a sale contract, for example, it is not allowed to say, I sell my house to you next month. This offer, even if accepted, is not valid as a sale contract should result in the immediate transfer of ownership to the purchaser. So we also learn that past tense, present tense, and future tense in using your contract. I mean, the phrase that use, we also asked you the question in the test, right? It has to be the past tense or the present tense. It cannot be the future tense. The second type under the classification based on the time of execution, the second type is aqd al-mudaf li al-mustaqbal. So there are some contract other than sale, all right? It is not sale. We are not talking about the sale or gift. Other than the sale and gift, there are some contract, the effect which could be postponed, because the nature of the contract is actually like that. These are the contract which may result in producing immediate legal effect, or the effect of which could be deferred to a future date. It can happen exactly right now, or it might happen also later. For example, kafala, right? You know, when someone say guarantee, so right now a bank is actually ready to give you the loan, and the bank is actually concluding the contract, selling you the house on the basis of the loan. But the bank is asking you, you have to produce a guarantor. Make sure someone, maybe it's your uncle or your brother, make sure that he become the guarantor for you. If in case you cannot pay the money, if in case you cannot pay the monthly installment, then we will collect from your brother or from your uncle. So this is what we call kafala, yeah? Guarantor, becoming guarantor. So now, right now, the moment your brother or your uncle comes and signs the contract as a guarantor, so right now, of course, the legal effect will start from right now, but it could be also postponed to the time that you miss the payment, which means that the moment that you don't pay your monthly installment, then your brother or your uncle has to become your guarantor, and then he has to pay the money to the bank. So the nature of that contract actually something that will produce immediate legal effect, or the effect can be deferred to the future date. In a contract of kafala, it is possible for a guarantor to say to the creditor that if the debtor, I mean the brother, yeah, if the debtor could not settle the debt within 2 months, then the guarantor would settle it. At the expiry of the stipulated period, the contract of kafala becomes effective, right? The expiry of the stipulated period, the contract of kafala becomes effective. So this is one example for kafala. The same thing goes to hawala. The same thing goes to wakala, for example, agency, right? The agency means what? Whenever I'm not in the city, so you will become the representative for my business. So that's what we do when we do agency, which means that I appoint you as my number 2. So as long as I'm in the town, I will take care of my business. But the moment that I go, you become my agent. Similarly, you can give your property to your agency, which means that right now you signed an agency for your property because you are not the expert. You don't know how to sell your property, but the agent, he knows how to sell your property. For example, you have an apartment, you don't know how to sell. So the moment that you sign for an agency, it happens immediately. The legal effect happens immediately, but it could be deferred to the date that the sale happens, because the sale might happen. The sale might happen maybe within 1 week, or maybe within 2 weeks, or maybe within 1 month or 2 months, right? Which means that the legal effect only happens when that sale happens. So similarly, the things go to waqf, which means that I have a property and I want to make it endowment. I want to make it charity for this particular madrasa, for this particular community, for this particular reason. But it will happen only after I die, because usually people give charity, the waqf, when after they die. So now the waqf contract happened at this moment, but it will only take effect after the death. So this is the nature of the contract, all right? We cannot change this. In a contract, yeah, this is what in the contract kafala is possible for guarantor to say the creditor. So these are the examples for the second type of the classification based on the time of execution. Now you have the C, number 3, which means that al-aqd al-mu'allaq ala ash-shart. Yeah, so this is what we call the contract, the effect of which could depend on condition. These are contingent contracts that may depend on the fulfillment of certain conditions. So now these examples that I'm going to give you, it is actually quite similar to the examples of the previous one. You see the examples of the agency comes again. The example of wasiya comes again. Kafala and hawala. Contingent contract could only produce their legal effect when certain conditions that are put by the parties are met. In a sale, when A tells B, if I travel, you will become my agent, B can only become an agent when A travels. So now, there are two things. You might say, I mean, this sale, I mean, you can become my agent from now on. Whenever the property is being sold, you become my agent. Another condition you can make, as long as I'm in the town, you don't have to be the agent. At the moment that I travel, you will become the agent. So meaning there is a condition. Also, waqf endowment as well. You can say that I make this property as an endowment to the madrasa or the masjid or for some other community purpose. It can be also become waqf, for example, only after I die. It can also become waqf before even I'm alive. I can also say, okay, even I'm alive, I gave it to the waqf endowment so that they actually can use my property. But he can also make a condition, no, do not use it right now while I'm alive, just use it after I die. So you can see that you can also bring a condition to the second category of the classification, which is the al-aqd al-mudaf li-mustaqbal. If you bring any conditions here, then it becomes C, right? Okay, now we have to move to the number 4. Okay, number 4 is classification based on nomination and non-nomination. So this is very simple to understand. Because Sharia, for certain contract, Sharia has already given the name, which means that you can see in sources of the Sharia, in Islamic jurisprudence, there are certain name has been given. For example, mudaraba, musharaka, wadi'ah, kafala, these are the names already has been given. So according to Sharia, it is called nominated contract. Contracts are also divided according to whether they are given a certain name by Sharia or not. If it is given by the if the names are given by the Sharia, then you can call it nominated contract. If there are certain contract, the names are not there, the names are not given by the Sharia, the names actually happened due to the common, due to the current or the recent or the modern world, then it is non-nominated contract. For example, mudaraba, musharaka, wadiya, kafala are grouped under the nominated contract. On the other hand, contracts that are later introduced, it came later. For example, istisna, what we are doing, like for example, developing, is a developer for a house, for a housing plan. He is actually building houses and apartments, and you have to pay first. What we call istisna, meaning you pay first and then you wait until he will finish the project. Also, by al-wafa, also takaful, for example. Takaful is like insurance. This contract was not there previously. This is something new. Only very few within this last century, within this 100 years, only we have this kind of contract. That's why these are the contracts. It's not in the Sharia, but it is actually still based on Sharia conditions. The only difference is it is not nominated by Sharia, but it is still contract. So this is another classification based on nomination and non-nomination. Then you have the last one. This is the last one. Classification based on requirement of physical possession. Most of the time, you know that there should be a physical transfer must be there, physical possession must be there. Then only you can have you can complete the contract which need the physical transfer slash existence. Physical existence of a thing include the contract of gift hiba, borrowing i'ara, deposit wadi'a, loan qarad, pledge rahan. In this contract, the thing or the property should physically be present and transferred, right? So you can see that in this contract, you can see those product, the subject matter must be physically available and it has to be physically possessed. In all other contracts, the physical transfer of the property is not necessary as long as all the pillars of a contract are fulfilled, then this is what we call the non-physical possession contract. For example, you do this kafala or hawala, right? Or wasiya, all these contract which is not necessarily has to be, there should be physical requirement. The physical requirement comes only when it is you are doing, like most of the time there is a physical, most of the time al-uqud at-tamlikat that you done before, the uqud at-tamlikat, most of the time of course there should be physical possession. But there are certain other contract like safeguarding contract, or musharaka murabaha contract, right? Or kafala, or or maybe hawala contract. These are the contract. It is only the contract in the paper, and the physical possession is not required, right? Okay, hope you understood. This is what we have: 5 classifications, 5 categorizations based on characteristics, based on purpose and effect, based on time of execution, based on nomination, based on physical possession. All right.
Sir,
Okay, please. Any questions?
yes, sir. Actually, sir, I want to ask is, under the first classification based on the characteristic, my question is, according to the Hanafi, from the notes, I quite confused, because I asked ASLR refer to the essential element, which according to the Hanafi are for an acceptance of. But why after that, the that and all feature require the part and the supplement. So I quite
Leon, your voice actually been cut. It's not clear. Can you repeat again?
okay. Sir, can you hear me now?
Yes, go ahead.
Okay. Sir. So my question is why because based on my understanding, according to the Hanafi, the essential element only two, which is the offer and the acceptance only, right?
Yeah.
But why after the sentences you mentioned that and all the condition required concerning the party and the subject matter? That's my question.
Yeah. Because this is I mean this question is not coming from this. It has to come from the original class. We studied in theory of contract, the 3 pillars of contract, right?
Yes.
Yes. This is the original question. I mean, because according to them it is 2 pillars, but according to the majority, these 2 pillars are only 1 pillar. Am I right?
Yes.
Okay, you're clear about it, right? Because offer and acceptance are 2 pillars according to Yes, Leon.
Sir, just now your line is no good. So
Oh,
yes.
okay. Can you hear me now?
Yes, it's very clear now, sir.
Okay, good. So I was saying the two pillars of a Hanafi is actually offer and acceptance, and these are two pillars. According to majority, is how many pillars? One pillar, which is the first pillar, right? So what are the remaining two pillars of majority?
That is the subject matter and the contracting party.
Very good. That parties and the subject matter becomes the two remaining pillars according to majority. But these two things, which is subject matter and parties, they follow the offer and acceptance according to Hanafi, which means Hanafi make these two things as a conditions for offer and acceptance. That's why from there, from the beginning, they agree that I mean the capacity, the legal capacity, and also the legal subject matter, it comes under asal. It comes under asal, the essential elements. That's why they said the essential elements refers to which according to the Hanafi are offer and acceptance and all the conditions required concerning the parties and the subject matter. Because according to them, if you go back to the slide, you will see that according to them, the second pillar, which is party, and the third pillar, which is subject matter, follow offer and acceptance. They follow. They don't stand separately like what majority says. According to Hanafi, they follow offer and acceptance, because you cannot do offer and acceptance without these two elements. I mean, without parties, without subject matter, how you are supposed to make offer and acceptance. That's the reason why they said the pillar number 2, which is parties, pillar number 3, which is subject matter, will follow offer and acceptance. So that's why it comes under asal. And the external attributes, whatever it is not in the essence of a contract, will fall outside of it. That's why they said, for example, you have the subject matter, you don't know how much the price. Yeah, or maybe you are doing everything complete, but the money involved here is actually has the element of usuri or the element of gharar, uncertainty. So these are the additional things. It contains a prohibited attribute, and according to majority, because of this prohibited attribute, the contract become invalid. But according to Hanafi, because of this prohibited attribute, the contract will become fasid. Why they want to say fasid? Because there is a possibility that you remove, you can actually alter, you can actually change this particular element. For example, you can take out the usuri element and then you bring the halal element. You can remove the unknown price element, and you can actually bring back the known price element, right? Something that you can bring back. That's why it becomes, they call it fasid contract. The fasid contract can become sahih contract.
So I want to ask just now, my example the contract which all right.
Yeah, correct. Yeah.
So can you repeat again? Like for next slide.
Okay. This one, yeah?
Yes. Like invalid or weak contract according to the Hanafi, that one.
Yes. You can
That one
see. Very good. You can see here that you see the invalid and void contract is actually, for example, the person who has no competence. See, I told you just now, right? When there is a problem in capacity or the problem in the subject matter, for example, the subject matter is not in existing, then definitely, like everybody else, the Hanafi also says this contract is invalid. They don't call this contract is fasid. The contract is done by the person who has no competence, or maybe unlawful purpose, or sales of invaluable property. If you are selling non-valuable property, definitely the sale is not the sale, because the asal, that's why they have the asal and wasaf. Maybe you can say asal means the primary. Okay, you can write it down. Asal means primary, wasaf means secondary. So when there is a problem in primary, the primary according to Hanafi definitely is offer and acceptance. Together with offer and acceptance, the conditions that follow the offer and acceptance, which means the capacity and also the subject matter. I mean the parties and the subject matter follow the offer and acceptance. That's why they also agree that if someone do contract who has no competence, or the contract is concluded for an unlawful purpose, or the sale of a invaluable property, or when the subject matter is not in existence, in this case the contract become invalid.
So can I say that, as you said that, like actually what's the meaning? Ask, why sir can say that like ask is the primary and the secondary?
The primary is asal.
Yes. Actually, what is the meaning like? It's the primary.
No, the primary is actually those things those things are the three pillars. If you want to know in easy way, I can tell you the primary means all three pillars. The secondary means other than the three pillars. For example, the unknown price. You have the product, you don't know how much the price, still you want to buy. So this one will become secondary, which we call it wasaf. But if there is no product, still you want to buy, then the problem is with primary, asal. You cannot do that. You cannot do that without the product. But you can do with product. But if you don't know the price, you have to wait until you know the price. As long as you don't know the price and you still do the contract, then it becomes fasid according to Hanafi. But according to Hanafi, they say it is fasid because there is a possibility that you might know the price. The moment you know the price, the fasid can become valid. The irregular can become valid.